We have a fun session today. We're going to always do our legal update with Amy, but we thought first we would do a Heard on the Hotline for everybody. And if those of you know, Jane Disher runs our MEA hotline, and she's going to kind of run through some of the most common non-COVID questions that come up. So I'm going to turn it over to Amy and Jane.
Thank you, Kevin. So before we get started, for those of you who are members, you're familiar with our hotline, and I'm sure you've talked to Jane or emailed with Jane, and we know she's awesome. So we get to hear from her a little bit more today. But we had, the word unprecedented has been used a lot in the last year. We had an unprecedented amount of volume on our hotline last year. We handled over 3,000 calls. And I say we, that's the Jane part of we. 721 of those were COVID related, even though some days it felt like they were all COVID related. And then our legal group handled over 1,000 calls. So that was markedly more volume than we had handled in 2019. And of course, we love talking to our members, but it really was a busy year for all of us. And Jane was a huge part of that. So what we did today is we picked some of the most common non-COVID related questions that we're going to have Jane address. If you have questions, feel free to chat them in. We'll handle those. And then when Jane is done, I'm going to come back on and I'm going to do a quick COVID legal update. Oh, I forgot this. The top categories of our non-COVID, not surprising, FMLA and FLSA, ADA, and then issues around policy development and termination. Some of the most popular in any year. Okay, so I'm going to turn it over to Jane.
Great, thanks, Amy. And first, I just want to say thank you to everybody who contacted the hotline last year. Thank you so much for your patience as we encountered unprecedented volume, and particularly for those days where we were doing in excess of 27 calls a day, and the days where it seemed like the information was changing from minute to minute. So thank you very much for your patience and support. So as Amy said, life does go on, though it's not all about COVID, and we still received a lot of calls and inquiries related to the categories that she mentioned. And so we tried to pick some of the most common things that we've seen. And one that we see very frequently is this question, which is, when are we allowed to dock exempt employees' pay? So Amy, if you can hit the next slide. So the wording that we've provided here is taken directly from the Department of Labor fact sheet related to exempt employees' pay. So generally speaking, exempt employees are paid whenever they work any part of a day or any part of a week. That's sort of the baseline. But there are situations where deductions from pay are permissible. And these would include when the employee is missing work full days, one or more full days for personal reasons other than sickness or disability, absences of one or more full days due to sickness or disability if the deduction is made in accordance with the bona fide plan, providing compensation for salary lost due to illness, for amounts employees receive as jury or witness fees or for military pay, penalties imposed in good faith for infractions of safety rules, or unpaid disciplinary suspensions of one or more days imposed in good faith for workplace misconduct. Now, it's also important to realize that you're not required to pay a full salary in the beginning or ending week of employment. So if an employee starts on a Wednesday and terminates on a Wednesday, you only pay 3 days. Or for weeks in which the exempt employee takes unpaid leave of absence under FMLA. Okay, next question. So an employee has exhausted their 12 weeks of FMLA. Their doctor has said they will need an additional 3 weeks of leave before being able to return to work. Are we required to approve the additional time? So let's start with leave may be an accommodation under ADA, but there's no specific amount of leave time that is required as an accommodation. And the employer must provide an accommodation under ADA unless doing so would cause an undue hardship, which is a fairly high bar to meet. So it really is up to the employer's discretion to determine if and how much leave is reasonable. So in this case, the requested 3 weeks leave may not have a significant impact on business operations, so may be considered a reasonable accommodation in this case. Okay. Next question. Our employee has a chronic health condition and has requested time off but that he does not qualify for FMLA. What should we do? Well, there are two parts to this. And the first question is whether ADA may apply. And if so, the employer may be required to provide leave unless doing so would cause an undue hardship, which we talked about in the previous question. The second question relates to whether or not you have a non-FMLA leave policy. And if you do, that policy should outline what conditions would qualify for a leave, the duration of the leave, whether the employee will be required to use any available paid time off, and how healthcare premiums will be handled, somewhat similar to how your FMLA policy would be structured. If ADA doesn't apply and there is no policy, then the question becomes, what has your practice been when an employee has requested leave of absence? And what's important here is just making sure that you are consistent in how both policy and practice are applied in this situation. Okay. Can an employee who is going out for a medical leave request that they use their PTO instead of taking FMLA? So here, as soon as the employer has enough information to determine whether the leave being taken qualifies for FMLA, you must notify the employee as to whether the leave will be designated and counted as FMLA leave. Employees don't have the right to choose when leave will be designated. It's up to the employer. And as soon as the leave qualifies as FMLA leave, it should be designated that way, regardless of whether the employee wants FMLA to apply. And I think one other important point I would stress here for employees who are making this request, one of the most significant benefit of FMLA is job protection. So making sure the leave is designated as such will protect their job while they are out. Okay, next. We get this one a lot. So during a performance discussion with an employee, they disclose a medical condition. What is our obligation to act on that information? Okay, so once you are aware that there may be a medical issue impacting the employee's ability to perform the essential functions of his or her job, you are on constructive notice of the need for an accommodation. So the employee doesn't have to say, I need this accommodation. You're aware of an issue. And so you are obligated to begin the interactive process with the employees. In this process, you're beginning a dialogue with the employee to determine if there are restrictions on their ability to perform the essential functions of the job, and if those restrictions may require an accommodation. And in this conversation, you're asking three questions. What are your limitations? What is the anticipated duration of limitations? And what accommodation are you seeking? You can then request medical information. And essentially the question a doctor is answering is if the employee is able to perform the essential functions of the job without an accommodation. And just as an aside, I would also say this is a really good reason to make sure your job descriptions are current with the most current essential functions listed, because that's information you'll want to provide to the medical provider. Okay. Can employers in Pennsylvania and New Jersey make direct deposit mandatory? I included this because we get this a lot, but I also wanted to just make sure, that we get a range of questions into the hotline, and they can be from very simple to very complex. And this is an example of a question that falls on the simpler side, but it's one that we see a lot. And the short answer is no. So in both New Jersey and Pennsylvania, the employee must consent before the employer can issue pay via direct deposit. Okay, this just harks back to what Kevin was talking about earlier, but we get this a lot. We have an employee handbook, but haven't done any comprehensive review in a couple of years. How important is it that we update handbooks on a regular basis? And I would first say, if you've called the hotline or emailed, when we're talking policy issues, my first question is always going to be, what does your policy say? What does the handbook say? So it is important to make sure that your policy, your handbook and policies reflect the current environment. And clearly, this past year has been a great example of how things change. I mean, I think I look back a year ago, and I don't think any of us could have anticipated what we've experienced. And Amy, I know will agree that when we started getting phone calls about COVID, end of December of 2019, we were kind of, oh, it's really not a big deal. And clearly it's become something none of us could have anticipated. So making sure that you have, that your existing policies reflect what's going on, or it may mean adding new policies to the handbook as well. And a great example of this is telecommuting, because we know lots of companies did not have a telecommuting policy a year ago. Many now do, given what we've been experiencing over the past year. And so making sure that you have a policy that's reflecting the way you're currently working. Emergency policies, closure policies, which had previously been primarily limited to inclement weather, now need to be expanded to cover other things like a pandemic. Technology is changing the way that we work, and we clearly see that with the amount of Zoom meetings that we're doing. And then the last thing, which Amy will be covering in a few minutes, is laws will be changing under the new administration. We talked about unionization, and so making sure that you have policies in place that can support your efforts there, including policies around solicitation and distribution, and making sure that your policies and handbook are an accurate reflection of your culture. Okay. This one we get a lot and see a lot. So we're thinking about developing a maternity paternity policy. What guidance can you provide? Well, the first piece of guidance we would provide is to call it a parental leave policy. Aim, can we get the, sorry, okay, is to call it parental leave. Rather than distinguishing between male and female employees, the policy should distinguish between parents who recover from childbirth and those who do not. So, and those who do not would be the people who would be for bonding. The other important thing to remember, this is especially true if you are covered under FMLA, you want to make sure that your parental leave policy is running concurrently with FMLA so that you're not stacking leave on top of each other. Okay, and the last question, again, this is one we see a lot. So when can we withhold money? For example, failure to return company equipment from an employee's check. So under Pennsylvania state law, any wage deduction must be for the benefit of the employee and may be made only if the employee authorizes the deduction in writing. In addition, generally, docking an exempt employee's pay is a violation of the federal Fair Labor Standards Act. And for non-exempt employees, it could violate state wage and hour laws if it drops the employee's pay below the minimum wage threshold. So, okay. That's the questions.
All right, that was our last question, but we did have a couple of people ask some questions come through. Okay. We'll just address those. One of the questions, and I answered this directly to the person, I typed an answer back, but one of the interesting questions that we got that I think might have some applicability to the rest of the audience is, what if an employee goes out on STD or there's a workers' comp situation, and so we as the employer already have a ton of medical information? Do we still need to go through the FMLA paperwork with those folks? And the answer that I gave to that person, and the answer I would give more generally to the group, is you don't have to. And certainly under FMLA and ADA, you don't want to be asking for extra medical information if you don't need it. So if you as the employer already have enough information either through STD paperwork or through workers' comp to know that FMLA is qualifying, you want to designate that time as FMLA, and you want to make sure it's running concurrently with the STD, with the workers' comp. Because as Jane said, FMLA is job protection. All this other stuff, workers' comp, STD, maybe paid leave laws under various jurisdictions, that's income replacement. They're really two different things. Employees focus on the income replacement, but you as the employer also need to help them through the issue of the job protection. So this is an interesting question, Jane. It's not something I've focused on with regard to FFCRA. What are employers doing if an employee is taking the emergency FMLA? How are employers communicating to their employees that that time is running on their regular FMLA? Are we sending letters? Are we sending emails? Are we doing a designation notice?
That's an interesting question, because we've offered an MEA drafted leave request form, but to the best of my knowledge, this didn't require a designation form.
Right.
So that's an interesting question. Beyond what was
Yeah,
the DOL poster, I don't really. It should be
right.
something
I would definitely say
that we might want to think about if it looks like this is going to get extended again with Biden. Because he
I would want to tell the employee in writing that this time is going to count against their FMLA, but I have not seen any kind of a formal designation notice from the Department of Labor that has to be used in that situation. Right. And then we have another employee another member who asked, if you have an introductory period before benefits become effective and a holiday falls within that window, can you hold pay for that day for an exempt employee? So let's say we have an exempt employee, they're working the rest of the week. Can you hold 1 day of holiday pay for them back? Any thoughts on that?
I guess I would want to know what your policy says about holiday pay.
Okay. Yeah, I would be really concerned about FLSA issues there, about not paying the employee their full week of holiday time. This came up a lot. It comes up a lot around the end of the year and holidays. What do we do about holiday pay when somebody's already run through all their vacation time, or when they want to take time off and they've already run through their vacation time? I would be real careful if you have exempt employees about not paying them for one particular day, but every situation is a little bit different. So feel free to call the hotline if you're a member, and we'll be happy to talk you through that. Okay, wait, I might have a couple more here. Hold on. Okay, that's all we got. All right, so thank you so much, Jane.